Hello,
Now you're
hello
live.
everyone. How are you? How are you, Jean? All good?
Doing good. A little bit sad with the results from Congo, but it's okay. Happy for Rob.
Yeah, congratulations to the English people from our community. I'm very sorry to the Congo members of the community. Yeah, I was we were watching the game in the background with Rob, who is in our board, and he's from England, so I mean, it was yeah, cool to see. I mean, I told him, and he will not let me lie, that England was going to win because they were playing so much better. So yeah, congrats, good job. Um, and okay, let's see a bit of the things we have been doing this week, past week. Actually, the first important thing, and I see we have already the picture there on the screen, is a conference called SubTech. SubTech conference is uh, very important conference in legal innovation that has been running since 1990. It was founded by a person called Marc Lauritsen. He's a researcher, professor, and practitioner in the field of legal innovation. And he started back then this conference to gather um, experts from different topics regarding like innovation and law. And well, this has been going on every 2 years in different parts of the world. And here we can see the list of cities. It started in Salzburg in 1990, then Chicago, Paris, Montreal. So yeah, it's been a bit everywhere, except for the southern hemisphere. It's and I was invited to the Chicago conference. This used to be like only by invite because it's a small conference. It's like 40, 50 people. Um, very of I mean, a very strong group and with lots of big influence outside of that network. And so I was really happy when they invited me in the Chicago 2024 conference that was held at Northwestern. This is a very important university there and with a very important law school. Um, and well, I went there and had these 2 or 3 days of discussions with some of the more brilliant minds in the legal world, in legal innovation world. And at that time, the like dinner at the end, the World Cup of Legal Tech. Yeah, at the end, I mean, they asked, I mean, they told me that they wanted to do an edition in the southern hemisphere, like maybe South America, and I was like, hey, I mean, I can try to help to do this, and so I um, helped organize this in Buenos Aires. It took a bit of time to do it, but finally we got to do it like last week. It was done at the University of San Andres in partnerships with the Center for Legal for Property Intellectual IP Law at San Andres. It's one of the most important universities in Argentina, and we got to bring lots of influencers from many places. So, and some of them actually were like some of the early day people. So we had, for example, Amy Schmitz. Amy is professor at Ohio State University and is an extremely highly influential person in the world of dispute resolution. Amy, she is a co-author of an important book called The New Handshake with Colin Rule, who is basically the guy who built the first crowdsourced dispute resolution process project in the world. It was done inside of eBay when they have disputes between buyers and sellers. But the most important type of dispute that you used to resolve there through other users, to the crowdsource of other users, was mostly reviews dispute. Hey, I sold you this and it was good, and then you put me only 2 stars. Like, hey, I want this to be reviewed by. So that type of disputes, which are very important in the reputation system. So so this is Colin Rule was the first person who like put this at scale. He did this at eBay back in the day, 2004, I think that started. So a really long time ago. So Amy was there. She's one of the most respected persons in the world of dispute resolution. We have Ken Sato. Ken Sato is from Japan. He came from Tokyo all the way to Buenos Aires. That's a really long flight for us. We had people from Germany, like George Borges. George is a legal innovation expert from Germany, and also like a part of the community. We had also people who are like more practitioners. We had, for example, Mario Adaro. Mario, who you can see in the picture there, he's a Supreme Court judge from Mendoza, and he came especially from Mendoza to the conference and to explain a bit on how our work together has been done in the past. As you might know, Mendoza was a pioneer in setting up a process where Kleros is used as what we can call a pre-settlement tool for disputes happening in neighborhood disputes in a particular judge in a city called Lavalle, and this was done through an agreement with the Supreme Court of Mendoza. And this is going to be someday in a history book for sure, because this was the first agreement that was done with a government for the use of Kleros for helping disputes. And this opened doors in other places where we are working now, like Junín, which is a city in Buenos Aires, or other things that I think would have been harder to do without his support. And so we had Mario, and we had other people who came more from the industry, from companies, law firms, some of them like IP law, others who are doing work with AI. And this conference, I mean, the main topic that was discussed was mostly about the convergence between law and AI. This is a topic that we have been exploring for a while. And now we started reviewing all this in 2019. The first time we mentioned AI and Kleros, it was even before Kleros, when I did that famous interview with Max Kaiser explaining how an agent would sue another agent. I didn't call them agents, I called them bots, I think. And then a panel of bots could be used to resolve those cases. Then 2019, after we did the Lodges on Trial experiment, we started to use some AI recognition, face recognition AI software to see if they could recognize dodges or not. And then lately we have been doing lots of more research, in particular with the use of AI models, LLMs, in order to see if they can resolve disputes. And my presentation in this conference was exactly about this. It was about the experiments we have been running, and in particular one experiment we ran with William. I mean, he can explain a bit more later. And William and Rob, by the way, where we use different models to analyze and vote on 99 lemon cases. And then on those cases, we saw that different models, we had a Claude and ChatGPT. Different models had different decisions. Some of them were more in favor of the consumer, other more in favor of the company. And not only that, but also when you have one model like Claude 4.7 and then you switch to 4.8, there is also a change in how they evaluate evidence and how they vote. So this is really important, because as we see more and more use of AI to resolve disputes, this idea of not being biased and how to prevent those sort of biases are going to be more and more important. And this is basically what I am mostly focused now. I don't know, Gene, if you want to mention something about the conference, as you have been there for one day. Yes. So,
Yeah, I think one thing that I was surprised by is that it really looks that these lawyers or these investigators, researchers, they are completely sure that the law will be different in a couple of months, years, and there's a lot to be done about it. So I think for at least my impression a couple of years ago is that lawyers were kind of resistant to change, and now there's a change in perception about technology. It's more like, okay, the change is coming. There's no way around it. So what do we do to make it work for us, like for law in general and for the regular people? So I'm not sure if the people that participate in the conference are like a good sample of the general legal scholars, but I think if they are, I think you're in good hands, let's say, because um, there's so many different ways where AI can be applied and benefit people. So I think it's good that the attitude towards it is, okay, let's use that in a way that helps us. So there were actually a couple of talks that were exactly about that, right? Where
No,
AI can help and
these
where it
people
doesn't.
these people are not really representative of the average, like person in the legal industry. These people were like coding, they saw everything. They saw. I was speaking with Ashley, and John Ashley, and he's a researcher from the University of Pittsburgh, and he is like at the age of retirement now, and he was one of the founders of the conference back in the day. And was telling me, look, I've been through all of the cycle of AI and law. First, when they started, what they were doing is they were like just using what they called expert systems. So you had the AI, and then you would code like the path of what the AI should tell to users. And like, for example, if you want to use an AI for like drafting a will, a testament, you have like AI, a program that they coded every little step with a decision tree. And then they were like, okay, do you have a wife? Yes. Or do you have kids? Yes. And then depending on what the people would answer, like they will come with a new question. And at the end, they would come up with a contract. So this is what they were doing back in the 80s and 90s. And then they come with machine learning, and now they can start to train them, with data, because of the internet brings more data. They bring more digital data, which can be used to train models. The idea of machine learning comes from the 50s, from Arthur Samuel and the experiments he was doing at IBM. And he developed the first model that actually beat, I think it was the Connecticut champion of checkers. And the AI in the 1950s beat that person, was Arthur Samuel. But, the idea of machine learning to actually train a model playing against itself. You need a lot more data, more computing power. This was not there in the 50s. It was in the early 2000s. So we had this deep mind companies. And the new iteration of all this, is like the LLMs. And one thing that this professor was telling me is that he did not foresee, LLMs coming. So, but it's really interesting because he has been, how many things that now we give for granted, but, it was not like that easy to see, even for experts back then. So those were some of the discussions we had. And one of the important and interesting things is that even if they are not representative of the general legal community, because they are really, really early adopters. If we are early adopters and innovators in this industry, imagine these guys in the 1990s, 30 years ago already, researching this. But what we see, and this is a first-hand thing we see, is that there is a changing generation of people in the industry, a changing generation that is bringing digital natives, internet native people into decision-making positions in companies, in regulators, in government, everywhere, in law firms. So, and these people are just used to a different way of doing things, a different way of resolving disputes. These people are not going to, their mental model is not about going to small claims court to resolve a dispute. Their mental model is, this should work like Amazon, dispute resolution or customer service. And this is something we see in our day-to-day conversations with people. And this is where all of these tools that these like innovators developed for, 30 years are becoming like, very much relevant right now for a new world of, cross-border, like small value, agentic dispute resolution, commerce. So, yeah, I don't know if you have anything to comment. That was a lot of talk from me,
Yeah,
Jim.
just another thing. I was also very surprised, like with the cases that people related to IP brought,
Yeah.
like what they commented. So there are so many issues that we, like, regular people don't even know about. I don't know, getting an artist, having something used by a generative model, and who is in charge of, like, who is the artist, the owner of the results. What if the model changes it a little bit? So what is the threshold where it becomes like fair use? So there's so many issues that come from, like, the way that the technology is being adopted, and it's almost impossible to get like a set of laws to take care of all of the details. So there must be another way of solving disputes, basically. So, and there's lots to be done still in this area. So I have the impression that the IP lawyers are always on the edge of the law, also because of that. I don't know what do you think.
This is natural because, like, there is this author called Kevin Kelly. He was the founder of Wired magazine. I got to meet him actually in person when I was at Singularity. He came to give us talk, and he has this book called The Irreversible, I think it was the name, where he explains what he imagines, the world to be like in 20, 30 years in the future. And one of the things that he says is that, we will probably make our income of little work we do in different, like, sub-communities, different types of content we produce for different, type of customers. Think of like an artist that has its The Inevitable was the name, I think. Yeah, The Inevitable, not Irreversible, but it's kind of similar, So, so it's this inevitable. But the thing is that you have some work of art, some, video, maybe this video even that you are watching now here is being to be used to train some AI model, and then with someone queries to make an image, it kind of takes something from us, and then, should we be rewarded for this? We kind of are owners of our image or not? Then this should be like maybe a small payment. So Kevin Kelly was saying, okay, the future is going to be like the future of income, of revenue for people is going to come from those type of situations where you start to get micropayment for lots of different pieces of your data that you provided into the world in different contexts. And you will have inevitably disputes on whether, this like image that was done by this guy in Korea and is being used for this commercial application. This guy looks a lot like Federico, should Federico, was Federico actually the image that was used for this, and should he be rewarded in somehow for this image or not? Think of, if you have seen like also this movie, The Congress, you have like a Robin Wright, Claire Underwood, for if you want. She sells her image to make an AI model, and that AI model, it's not a model, it's like an AI duplicate of her, and this is used in movies, right? And so, and she gets a payment from royalties from the use of her image in those movies, AI movies. And then, so all of the world of the future is going to have a lot of this type of situations where you have like this AI and content, and the way to monetize this is it's about property rights, about intellectual things, about image, about brands, about songs, about videos, photos, and the way in which you distribute this property and the rights to this property and those royalties is going to create a lot of disputes. This is why IP people are super interested in it. And we are already seeing the first disputes about this, about New York Times against OpenAI. And there's a bunch more of those cases where owners of rights claim that their produced the intellectual property was used in an unauthorized way. And then and the interesting, these are like class actions because it involves a lot of people. So there lots of people and lots of things that are in connection to IP, and this is why also IP people in the digital world, are very much interested in all of these type of situations, and this is why also they are interested in Kleros, because Kleros is obviously a very good tool to resolve all kinds of situations happening in this ecosystem. I see that we are already half an hour into this. We have not planned any like this. Gino, if we want to add something about the conference, I can start speaking, and then it could be for hours like this.
I think that's it. I think we can move to the next topic.
One more thing. This gives me the perfect way to jump. So AI, Kleros, we. Just yesterday, and we did not plan this like this. So the Stanford Journal of Blockchain Law and Policy published a new edition, where they are presenting a number of papers regarding the Kleros and Stanford Symposium, where we made a call for papers. We are one of the supporters of this journal. William and myself, we are also on the board of advisories, and then we made a call for papers about AI and Kleros and how different topics that people could be interested in researching regarding the convergence of blockchain and AI, and from many different perspectives, from like AI alignment, AI governance, how to use AI to improve access to justice, to improve like the transparency, and many more things. And this was an open, and we got like excellent submissions. And I was not involved at all in the selections. We had tons of submissions. This was then selected by the team of the journal, and it was really interesting that one of the papers that were accepted was by Sophie Nappert, who is a very known arbitrator and friend of our community. And I just learned this yesterday in the evening, and I saw she wrote about constitutions for AI frameworks, this like anthropic type of approach to what an LLM should and should not be allowed to do. I haven't read the paper, so I only saw the title. I didn't have time for now, but I will. This is something that is really interesting to me. We had I remember a community call when we discussed agentic frameworks, and then I mentioned a bit about how Kleros can be used as a kind of a AI governance tool, where you have a jury, a panel that will decide if some model is misbehaving and potentially activate a kill switch or stuff like that. So a kind of constitutional, guardrails for. So if you are into Kleros, AI, and all this, just read that this has a bunch of papers which are super interesting. I promise we did not plan this way, but the timing was perfect after SubTech, because it brings this, everything was perfect. And how these topics that were super futuristic when these people started working on them are now being published in papers in a very well respected, Stanford journal. So that's really amazing. Things are really converging and happening. Do read that, and I will try to read as soon as possible the papers that were published, because it's really interesting. I don't know, anything to comment about this, Jin?
No, I think that's it for I think for the academic part, unless William has something to share, but I think we will have him later, right?
Yeah, we can go with Fortunato now, because the academic part is where we have the ideas, but the idea for this is not just to do academic stuff, because but that's important per se, but also to try to have like an impact in, so all of these academic things we do are supposed to have an impact in so products in real world like applications, because that's our ultimate goal. Well, we have here Fortunato, who is the product manager for Curate, and he can explain a bit of the type of work we are doing with agents and all that. So, hello, Fortunato, how are you?
Hello everyone. I'm doing great. Great talks and great introduction about AI. I think it is extremely interesting how AI and how quick AI is shaping our world, not in a way maybe that we would have imagined. Because I think maybe 10 years ago or more, when thinking about AI and the potential risks of AI were usually related, to Skynet and AI taking over and fully autonomous agents. But
we don't know if it's going to end like that.
Yet, for now. And today we are facing a lot of challenges, and I mean literally now, in terms of creating a lot of content on social media. And we also have one fellow that is working with Curate on curating AI's lot on social media, or also the intellectual property, as Jean was mentioning, how you attest that a specific creator should receive a fee if you just slightly change or use that image. So we have like a lot of these problems that were even at the center of the conversation when I was in Berlin for the Berlin Blockchain Week. The AI was the main topic related to security, because there is way more code is being produced, way more vulnerabilities, because the code is built by AI and maybe has not been correctly verified and vetted, and also hackers using AI tools to find potential vulnerabilities. So it is extremely interesting, and on our as Kleros, as Curate, we are trying to go side by side with AI, and in few days we will release the Curate skills. So users will be able to interact with Curate smart contracts directly with their agents, and this will make the experience way more smooth, but also I would say also safer for the submitters, because it's like having a sort of companion helping you in submitting. In fact, that's why it took us a bit more to release these skills, because we designed them, I would say, on 3 different levels. The first one is if someone wants to set up a completely autonomous agent, maybe you give the skills to your agent, and you just tell your agent, make money with these skills. And the agent maybe will be a challenger, will be a submitter, and will do everything on its own. It can be also a semi-autonomous agent. Let's say you are a project, you want to be tagged on Etherscan, and in order to be tagged there, you can submit your tag on Curate. So you tell your agent, please submit this item in my submit this item for me. And then there is I would say the lowest level, which is also extremely popular, that you use just the agent with the skill as a support. You want to submit through the front end, you give the skill to your agent, and you just tell your agent, okay, before I submit, please double check this entry. And the agent will check the policy, will check the information you are submitting, and after that it will tell you, I think you should adjust it, or it's good to go, or in case of my agent, it gave me the probability I would have been challenged if I would have submitted that policy. And this last thing,
let me translate a bit this for people who are not extremely familiar with the app, so everyone can follow. So one of the uses of Kleros is well known, for dispute resolution, escrow, Alice and Bob cases. But one of the main applications that is also very important and is very much used is for curation or certification. So one of the particularly is a list of certified smart contract addresses or like crypto asset addresses where people can submit an address that they want certified for being safe, for not being scammed, for complying with a number of conditions. And the community will check whether that item that was submitted to the list complies or not with the requirements. So this is what some people have called in the past a sheriff system, decentralized sheriff, where everyone can be a sheriff, and if they see that some item is like breaking the law, they can challenge it, and then there's going to be a trial made by people from Kleros and jurors who will make a decision, and the winner will keep the deposit of the other. It's kind of a bounty system, as it was very common in the Wild West, if you want. And how this used to work typically is through people just making submissions, others going to a website, checking if the submission was or not compliant, and then making a transaction to challenge or not challenge. And that was how it has worked for a long time, since 2019. That is the first time we launched this. And now what we are starting to do through what Fortunato is explaining of the skills is, okay, what if I don't want to do this myself? I just want to have like an agent program it and ask him to, okay, I want you to look for submissions that are valid in this registry, and then make the submission automatically. And I just put some money into the agent, and the agent does everything by itself. And other people who have other agents can challenge the submissions that my agent is doing, and everything works in a more or less automated way. And maybe, who knows, maybe if there is a submission challenge and a panel of jurors, those jurors, you guessed it, could be also like AI agents. So this is the type of use cases that we are, I'm not even going to say thinking of, we're implementing, because this is actually like something that is working now. And so this gives some context to people who maybe are not following that closely. Fortunato, so now you can continue.
Yeah, as you were saying, I 100% agree. And this is something we have already done. We will make it public, I think, in a matter of few days. You will already see it on our front ends, and you will be able to test these skills. And to continue what Federico was saying, I think that this is interesting not just if you want to participate into the existing lists, but this also is interesting if you want to create a list, if you have some data that you want to double check or verify. This is extremely performing, because imagine, like, normally you maybe have a data set and you want this data set to be checked against a specific set of rules. Normally, you could delegate this to a specific private data company, give the data to them, and they would privately analyze everything. But if you're going to use Curate, the advantage is that you would have probably 10 different AI models, 10 different challengers checking your data against the requirement, and you will have way better outcome in less time and lower costs. So the application of AI related to curation can be really from all possible angles, whether you want to create your own list or whether you want to be a challenger and make money out of it being a sheriff, as Federico was mentioning. And these skills also will allow us to move forward with the ERC 8004 standard. We discussed it back in February, March when it was launched, and we are still working on it. And we have already several partners who are interested in working with us related to these specific standards, not just from curation, but also related to court, because as Federico mentioned, the AI players may not just be curation, but you may also have AI jurors.
There you go. Then, not the future. I mean, this is happening now. This is something that is being implemented. This is something that is now being discussed at the highest levels even in the traditional world. You are seeing already companies from finance, that have already announced their plans to do agentic commerce, credit card companies. So all of this is happening. So, and we have been following this for a very long time, and lots of these things that were ideas for a long time are now starting to become realities. And we're happy to be at the forefront of all this.
Yeah, absolutely.
Anything else,
also,
Fortunato?
I think with this, just wanted to add that I think that surprisingly, as in Web3, we have a significant advantage on testing these AI agent and the potential applications, because the Web2 companies, they have to think more about how to set up the agent's interaction. But with whoever you talk, it feels like the native, if we talk about payment, the native payment methods for an AI agent is certainly with crypto. Now, of course, we have the regular institution which are catching up and providing, we have Stripe, I think also Visa, they are providing tools for AI agents. But in Web3, we definitely have, I think we still have an advantage in operating with AI agent. And we are definitely in the forefront of the development. So the last topic I wanted to share today is related to some update on the Scout registries. Last week, we created the new court, which is a new court on curation with hidden voting. And today we released an article and we shared the day where we will move the Scout registry from the current court, Curation, to the new Curation court, which is exactly the same. All parameters will be the same, except it will be with hidden voting. And these we also are curious to see if there will be any differences in the outcomes of the disputes. But what I am quite confident, what I am sure is that this is certainly an upgrade, even for our users that will have a higher perception of fairness, because sometimes talking with our parts, with the parts in a dispute, they may be doubtful if maybe there are some herding effect where the jurors just follow the herd, just follow what everyone else is doing and influencing appeals. And we will see if with hidden voting from the very first round, there will be any differences, because of course, before doing this, we ran all the stats internally, and we made this proposal which passed. And 13th of July, make sure if you are staking on Curation Court, make sure you will move you will migrate your stake. And if you're interested in participating, you can also start as a juror on Curate, because we constantly get cases there. And you can see how the Kleros court works. And I think that probably William can also give more insights about hidden voting and disputes.
Yeah, actually, you gave me the perfect time to call William into the stage, because this is, we actually, we have been, lots of different things going on with William. And particularly, we are writing a book chapter about Kleros and DeFi and the different experiments and what we have done for resolving disputes on DeFi. And one of the main things here is how you can use Kleros to avoid disputes ex ante through. A good curation is better than excellent dispute resolution, because you can avoid the dispute from happening in the first place if you have a compliance layer of, if you avoid some token that is of dubious quality to make it into some registry, then you might have less of a dispute about a rug pull happening or like whatever. So, and in this chapter that we are writing, one of the reviewer was asking lots of questions about usual objection to the Kleros mechanism about how is this not like a beauty contest in the as Keynes beauty contest. So we have William to give us the perfect answer for this. Hello, William. Yeah, please go ahead. You're mute. Yeah.
On the computer.
No, you're mute. On the computer. Yeah.
You don't hear me?
Yeah, now yes.
Now we do,
Okay.
yeah.
Good. Yeah, so this is a common objection that we've had many times over the years. That is basically an objection to all Schelling point mechanisms. That you have people that are incentivized to agree with each other, and if I have some kind of like minority of experts that like might know better, they think the crowd is doing A, but they realize the right answer is B. How do you incentivize them to give the real answer B? This is a sort of a research problem that's predated Kleros. There are lots of people in the pure prediction literature who've thought about this. If you're familiar with Bayesian truth serum and sort of surprisingly popular mechanisms, that's sort of as an approach to that. The work of Prellick. I've spoken about this, I think, at ECC last year. I had a talk that had a lot of these themes in it. Fundamentally, like, it's really hard to come up with a mechanism that it's not majoritarian, that doesn't just like listen to what the crowd thinks, that is also resistant to things like 51% attacks and various kinds of like collusion and such. In crypto particularly, where you don't have like a centralized third party to kind of enforce ad hoc, this looks like an attack, I'm going to ban these people. Kind of the best thing you can do is have a Schelling point mechanism, which, will always have some of these Keynesian beauty contest effects. That's a limitation. But at the same time, there are a lot of mechanisms that have Keynesian beauty contest effects that produce lots of useful information in the world. The original example of Keynes, when he coined this phrase, he was talking about financial markets and how the price of a stock can maintain like a value that's detached from its economic reality for a long time, just because like everybody else thinks that like it's going to have that value, so it can maintain that value, even if it's not what it's really worth. And nonetheless, financial markets are useful to like give us information about asset pricing. So like ultimately, my reaction to this criticism is that we've put a lot of thought into making sure that these mechanisms are like robust to groupthink as possible. You can appeal, you can like argue your belief in front of the appeal jurors, and really only that you have like a failure case if like you can't convince with the best evidence and arguments you have at like the last appeal the community of the correctness of your position, which is like an edge case. Maybe that the fact that edge case is there means the Kleros isn't quite as robust as like the Supreme Court in some kind of like country with a robust rule of law. But the flip side is that like these decentralization aspects make Kleros cheap and accessible in ways that those other mechanisms aren't.
Also, there is a philosophical, thing here. Like in the sense that Kleros is asked to resolve situations and make decisions in situations where there is not an easy answer, because there is not like a God's eye that can give us an external perspective on whether this job was done to the standards that was agreed or not. No, we don't have like an external answer to which like the jurors can try to truth track into. And this is like so. Since there is not like a external real answer that we can try to get, what jurors are doing is like try to in some way generate this truth through like some intersubjective agreement. And this is at some point, if you don't want to call them Schelling points, because it's too game theoretical, there's like a consensus, like a common knowledge situation of what is a community accepted way of finding something. and constructing some socially acceptable decision about some topics, where you don't have like a clear answer on what it is, but not anything goes. There are some rules within which the decision should be done, and then the way in which this is justified it matters a lot. I mean, because people need to buy, especially the losing party needs to buy into why they lost, in order for the mechanism to be like seen as legitimate and adopted. Otherwise, I mean, if it's just random, kind of coin throwing, I mean, we don't need Kleros for that. You can just have a monkey throw coins, right? So yeah, there is a lot of philosophical discussions on what exactly are Schelling points tracking, and there was an article, a blog post published, I think, less than a week ago at the Oxford blog that objects to this Schelling point situation, or this Schelling point approach, not only of Kleros, but of other processes of dispute resolution, like subjective oracle, if you want to call it that way, like UMA. We haven't had the time to answer to it. We will try to produce an answer, because it's a very good article with many fair points, and it deserves an answer. So we will ask for our right to reply to that. So that's it was published. I mean, you can share it, Jean, for people who want to read it. It was published at the Oxford Law blog, so that's a really philosophical question, but. Another thing to add to this is that for this solution to be seen as legitimate, there is also what the process looks like, in the sense that is it fully financialized? Is it just anonymous people voting through a coin to maximize financial gain? Or is this some other like social dynamic about who gets to decide, how they get to decide, how to justify their decision? Maybe, William, you can speak a bit about this, because this was the topic we mostly addressed in the Oxford conference we held a few weeks ago. I know I'm throwing at you something very hard to do in 2 minutes, but just say one thing you deem important of all of this first versus second generation dispute resolution systems.
Yeah. So I mean, on the sort of like financialization points, at some level, financialization is inevitable when you don't have good identity mechanisms, and this is a theme that we've thought about in the research for a long time. That ultimately, like, how can we improve the identity aspects, reputational aspects of Kleros, so that you can have a system that looks more like what people expect from like Web 2 experiences, that's less financialized, that comes with like, financial aspects are still there, because we can, in some cases, they're complementary to like the kind of reputational or identity aspects, but like, screening jurors for being on proof of humanity, so you only get one vote per address, one vote per human being, like requiring SPTs that attest to certain kinds of like expertise, and then once you've integrated in those extra tools into the system, how does that complement the security compared to the financial aspects? And can you get something that has the robustness of the financialized version of Kleros, ideally even more robust, because you have this extra layer, in addition to having more of a Web 2 kind of experience.
There's tons of discussions on whether this also, besides of this being seen as like ethical by traditional standards of ethics and dispute resolution, also needs to be compliant. There's a lot of questions around whether this is compliant in the context of New York Convention, and we're doing like lots of research about this, and adapting the mechanism for this to be compliant. We will address this in another call, because this is already way too long. I don't know, William, if you want to add something about this, so current research or the rest?
No, not. I think we've talked a good amount about these topics. In terms of other research, the devs are working on the dispute kit for the forking now. So I've been doing a lot recently, reviewing the sort of forking mechanism in the yellow paper, in terms of like how they've been simplified into what they're actually going to be using in dispute kit, to like make sure we still have good guarantees, and like doing like backs and forths with the devs reviewing that. But that hopefully will be out soon. So that's another sort of big aspect of V2.
Cool. Well, and to go to the important stuff, what are you thinking of the Canada's performance in the World Cup?
I had a great game the other day against South Africa. I'm really glad to see that Alfonso Davies made it back and is like contributing. I hope he's like fully healthy and ready to go on Saturday against Morocco. It's a historic run. Compared to like where we were like 10, 15 years ago, we were terrible. And now we've reached a level of respectability that I hope we can continue.
I think one thing that is we are learning in this World Cup is that there are no easy games. This is extremely hard for all of the big teams. I mean, I'm a bit scared of Cabo Verde. I mean, I didn't even know what Cabo Verde was until like 2 weeks ago. But now, I mean, I'm having nightmares with that. So yeah, we'll see. Thank you, William. Well, Jean, I think that we have covered most of the topics. I don't know anything else that we want to mention today.
Yeah, I think one thing, there's a proposal right now in the Kleros DAO about the disclosure of spending of the Kleros Cooperative. So I recommend everyone to check that and vote.
Yeah, also to mention that the Cooperative also has already legal disclosure obligations. I mean, I don't know what the DAO, but yeah, there is already a framework there. Yeah, please.
Yeah, and we also have like the monthly reports about the treasury, and the spending. So there's a lot of data already being published.
Yeah.
And another thing that I would like to invite people to join the cooperative because we have annual meetings and there's more being discussed in the cooperative, and you have a vote on some decisions. So yeah. For people interested in really participating at Kleros, I think it's a good idea to join the cooperative.
I think if you are part of the community and you are interested in what's going on, and I mean, there's really no excuse not to join, otherwise, because people can join. If you're a juror, yeah, really, there is no reason I could think for people not joining if they are interested in what's going on and want to have the voice and vote. So yeah. Please.
Yeah, I agree. And we have like a section on our website about that with both the reports and how to join the cooperative. So really recommend checking that. And another thing, just another reminder to migrate the stake from the normal Curation court on Gnosis chain to the hidden votes court, like Fortunato said. This will be the cases will start migrating there in around 2 weeks. So if you can do it before, maybe you can even have an advantage if you migrate before the others. So you might get more cases. So yeah, I think these are the main things.
July 13th, so the day before the French Bastille Day. So I mean, do migrate before that, because Bastille Day, what happens to the people who are in the monarchy side. No, it's just a joke. We're not going to enforce anything like that. So okay, I guess that's it, Jim. Or do you have anything else to?
Well, there's probably more things, but I think we should cut here.
Yeah, we cannot put everything, and we've had to leave out all of the enterprise kind of news that we have a bunch. But yeah, I mean, we need to keep people, entertained. So I guess then, guys, thank you very much for listening, for coming. Anything else? No, we're good.
We're good.
Yeah. Thank you, and see you next Monday at 6 p.m. Buenos Aires time for the Spanish community call, and otherwise on the next 6 p.m. UTC for the English community call. And good luck to everyone with your preferred team for this World Cup. See you. Bye-bye.
If you don't have a team, root for Argentina. Bye.
See you. Bye.